This program is brought to you in partnership with the Immigrant Legal Center.
Welcome to Legal USA, a monthly program produced by New Americans Media in partnership with the Immigrant Legal Center, both of Omaha, Nebraska. We would like to stress that the information provided here is not intended to be legal advice. Viewers should consult a qualified immigration attorney to obtain legal advice on their issue or problem. Today's topic is removal and deportation. Jacob Huju is a rural capacity building supervising attorney with the Immigrant Legal Center and joins us in the studio. Thank you, Jacob, for being here today.
Thank you for having me. I'm excited to talk about this topic.
All right, and let's start with some definitions. First of all, can you tell us what are removal proceedings?
Basically, removal proceedings are the process by which the U.S. government is trying to say that a non-citizen should no longer be in the United States. And it's at the end of these that, unfortunately, there's the possibility of being forcibly removed, or deported is another word that you might hear colloquially. So removal proceedings is that process.
Okay, and we'll get back to the definition of deportation. Sure. And how can we use the word, or what it means, the word deporting. But first of all, what are the processes, rights, and government agencies involved in the removal proceedings?
So first, because all people in the United States have constitutional rights, there is the due process of having a chance to know when your hearing is and what the government has against you. So that that process is found under the Immigration and Nationality Act. Now, the rights that immigrants have in removal proceedings, there are quite a few. The right to have an attorney at no cost to the government. So that means that if you can't afford an attorney, you might have to proceed in removal proceedings without an attorney. But you do have the right to be provided a list of available legal resources, a right to contact your consulate, the right to have an interpreter in your native language during the proceedings, a right to present your evidence, to cross-examine or ask questions of the government's witnesses against you, and then also, as I mentioned before, the right to due process. Now, some of the government agencies involved, this is a pretty long list and can get complicated. But under the Department of Justice, which is in the executive branch of the U.S. government, there's the Executive Office of Immigration Review, or EOIR. And then under that agency, there are the Board of Immigration Appeals and the Office of the Chief Immigration Judge. So the Office of Chief Immigration Judge is who oversees the immigration courts themselves. And then the Board of Immigration Appeals, which I think we'll talk about a little later as well, is kind of like the Supreme Court of immigration law.
Before we move on to the next question, can we go back to that representation, if you can have legal advice or not? I just want to clarify one more time that the government, if you are called to appear at the immigration court, the government cannot provide legal advice to you, but you can hire an attorney. Is that right? If you can.
That's correct.
Okay.
If you are able, you can hire an attorney. The government will be represented by an attorney under the Department of Homeland Security, so that's another agency involved in removal proceedings. But for yourself, you have the right to have someone represent you if you can afford it.
If you can afford it.
The government will not give you one for free, but if you find one, they can speak on your behalf and make arguments and prepare your case with you. If not, then you'll be on your own. Okay,
and then if not, the other option, you mentioned that the agency will provide you with a list of available organizations that may provide free legal advice or free legal assistance. Is your organization that you represent one of them?
That's correct. The Nebraska Immigration Legal Assistance Hotline, or NELA, is an organization on that list for the Omaha Immigration Court. And I believe the University of Nebraska-Lincoln legal clinic
Okay.
at the law school.
So this is down to the Omaha level, what you just mentioned.
That's
okay. Right. Now, can we go back to the difference between the word removal and deportation? I do understand them, what they mean. However, can you interpret them for us? I see them used interchangeably, as you said, but how does removal differ from deportation?
So in 1996, there were some changes made to the Immigration and Nationality Act, and those changes got rid of the old system that used the word deportation proceedings as well as exclusion proceedings. And those were two different processes depending on if the government was trying to say, we know that you're here present in the United States and we want to deport you. Those would be deportation proceedings. Or exclusion proceedings before 1996. Those were where you were trying to enter the United States to be admitted into the United States, or you had already entered without inspection and the government was saying, we didn't have a record of you entering, so we're saying you're not allowed to be admitted. Those were exclusion proceedings. But after 1996, they kind of folded those together into one process called removal proceedings.
Now, how is immigration court different or alike compared to legal or criminal court or civil court?
So this is a question that we get a lot because people are kind of familiar with criminal court or civil court. So as I mentioned before, in immigration court, you don't have a right to an attorney to be present with you at the cost of the government. That's one major difference from criminal court.
Okay.
And if, however, one big similarity is that immigration court is still an adversarial system. So there's one side against the other. The government is charging the respondent, the immigrant, with some type of ground of inadmissibility or deportability, a reason that they should be removed from the United States. And then that respondent is arguing against the government to say why they should be allowed to stay or why there's a reason that that is false.
Okay, so so basically there are, you're in court. There is a violation, but it's violation of immigration law, and then in that case you're sent to immigration court. Is that right, Jacob, if we kind of group the kind of violations?
That's correct.
All
The
right.
immigration violations are not criminal violations. They're not crimes, and that is why you're placed into a civil proceeding, an administrative proceeding within the executive branch within the Department of Justice.
Okay. Now, and I would like you to give us an example, if it's possible. How does someone end up facing removal and being sent to immigration court?
So that is another one of the agencies that is involved is Department of Homeland Security, of course, and Immigration and Customs Enforcement. That is the agency that issues what's called a notice to appear. A notice to appear is the document that informs the immigrant or the non-citizen why they're being placed in removal proceedings. It has the identity of that person, the type of presence that they have in the United States, so how Immigration and Customs Enforcement found them, whether they were arriving at the United States, they were present without being admitted or paroled, or they were previously admitted, but now there's a reason to...
They violated their visas, basically.
Correct. And those are all presented as factual allegations in the notice to appear, so that's a list of this is this person, they are a national of a country that's not the United States, this is what they did. And then charges you with a form of inadmissibility or deportability. And those are long lists of reasons that someone might find themselves in removal proceedings.
Okay.
And
if you are in that inadmissibility category, not the deportability category, which one of the both has less chances to be reconsidered and for you to stay in the United States? If those two are taken to the court, which one is more like, okay, you have done this, but you will still allowed to stay in the United States?
So one of the main, the most common reasons for inadmissibility is being present in the United States without having been admitted or paroled. And that's a ground of inadmissibility under INA 212A. That's unfortunately really difficult to counter, to say that's not true, because the government will have the evidence of who you are, that you didn't have a visa or a proper way to enter the United States, and that you're currently here present because you're here in the court with us. So that one is pretty difficult to counter. Now, for some of the forms of removability, or deportability, those are based on crimes that may have been committed, and there are some ways to challenge whether a certain crime falls under one of those categories of deportability that allows you to be removed from the United States.
Okay. I would like to go back to that notice to appear. My understanding is that a copy of it is sent to the immigration court and a copy to the immigrant who is thought to have violated the immigration law. What is your advice to an immigrant that out of fear says, no, I'm not gonna go to court? Do you encounter that case at all when they just ignore the notice to appear?
My first advice is appearing in immigration court is very important if you're ordered to do so. If you don't appear, the immigration court can remove you, can order you removed without you being present to argue anything. If you do appear and appear unrepresented, often the immigration judge will give you a certain amount of time to find an attorney. My advice is if you are served with a notice to appear, try and find an attorney as soon as possible. Okay,
so that would be the right thing to do. All right, I received the notice to appear. I'm an immigrant. I appear in court. I made the right decision. Now, what do I have to prove in immigration court? What are the parties involved? You touched on it a little bit, but can you just describe inside the courtroom what happens?
Yeah, so when you enter the courtroom, the immigration judge sits above everybody and would call up the next case, and they announce who's present, the reasons we're there for that immigration hearing, so that they'll announce that the government is represented by attorney so-and-so, and then that the respondent, the immigrant present in court, their name and their registration number, their alien registration number, and then if they have an attorney, they'll announce who that attorney is as well. And then at that point, the judge will ask whether the attorney is ready to plead the allegations or admit the charge. And that's basically where there's a chance, if there's something factually incorrect in your notice to appear, that's where the immigrant has a chance to say, no, this is incorrect. I did actually have a visa, or that's not my name, that's not my date of birth, you're charging the wrong person. And if that happens, then the government would have to prove with evidence, the factual allegations and the reason they're being charged.
Okay.
Often the notice to appear is correct. There's nothing to challenge in it. If that's the case, then you move on to kind of the step 2, which is where you would present a defense to your removability.
Okay. So step 1 was presenting the parties, right? And introducing what has allegedly happened. And the second step, one more time, you said is?
And then the second step is defending against your removability.
Okay.
And that is where you would present an asylum claim, or if you have a way to be present in the United States under the law. Okay. That's where you would argue that application.
Okay. But what if I don't have? What happens to me if I don't have basis, if I don't have grounds to continue to defend myself?
If you don't have if you're not eligible for one of the defenses to deportation and there's no way to challenge the pleadings or challenge the notice to appear, then unfortunately you would be ordered removed.
Removed. Okay. Before we move on to the removal, the technical part of the removal, so we are still at the court. You mentioned asylum as one of the grounds that you can defend yourself. Are there other ways that you, as an immigrant, not can use in the bad sense, but can use to your benefit to still pursue citizenship in the United States or permanent residency in the United States?
Yeah, there are. So there are provisions in the INA that allow immigration courts to process applications for adjustment of status. So I think your last episode was on family-based immigration.
Yes.
So if you have an approved I-130 petition and you're eligible, there's a visa available for you to adjust your status, the immigration court can actually process that application as a defense to your removal. Because once you become a lawful permanent resident through that court process, there would not be a reason to remove you.
Okay.
Another one is called cancellation of removal.
Okay.
And
please, I have encountered that term quite a lot. Can you please elaborate that a little bit more?
Yeah, so it's kind of a carve out of the more general family-based processes or other employment-based processes. It's only available to people who are in removal proceedings. So if you are present in the United States and you don't have any removal proceedings pending against you, you're not eligible for cancellation of removal. But if you're in immigration court, and there's two types of cancellation. One is for lawful permanent residents, and then the other one is for people who are not lawful permanent residents. If you're a lawful permanent resident and you've had that status for at least 5 years, and then you've also been continuously resident in the United States for at least 7 years, and you have not been convicted of an aggravated felony, then you're prima facie eligible for cancellation of removal. That means you've met the criteria. But there's one other wrinkle, that there are only 4,000 grants available for cancellation of removal per year.
Okay.
So you would want to also prove that you're kind of a better candidate for cancellation of removal. And ways to show that are your connections to your community, that you have U.S. citizen family members, or other examples of things that generally prove that you have a connection to the United States.
Okay.
So that was the lawful permanent resident cancellation of removal. For non-LPRs, non-lawful permanent residents, the requirements are a little more stringent. You have to have been physically present in the United States for 10 years and be able to prove that you've been here for 10 years. That you've had good moral character that entire time of being in the United States, and that you haven't been convicted of certain criminal offenses. And then lastly, you need to have a qualifying U.S. citizen or LPR spouse, parent, or child that would face exceptional or extremely unusual hardship if you were deported.
Okay. And there's no cap in this cancellation, the second category of cancellations, right? You mentioned 4,000 for the LPR.
The 4,000 is for all cancellation of removal.
For all together. One more, yeah, certainly, immigration law is not easy to navigate, but one question that I have noticed now that if the visa cap is met for this particular year, you still can wait for the next year, and maybe you're lucky next year. Does it apply in the case of cancellation, that rule?
Unfortunately, it doesn't,
because
this cap is separate from the kind of general caps.
All right. Okay, so we covered the inside the courtroom. The judge decides that I'm going to be deported. First of all, is there a difference between removal proceedings when you are in immigration detention and when you are not detained?
So the short answer, no.
Okay.
The proceedings are generally the same, but there are a couple of differences. For those who are detained, there is the possibility of seeking immigration bond. And if your criminal conviction is not so serious that you're ineligible for bond, so that is where the immigration judge would decide whether you're a danger to the community.
Okay.
If you're not a danger to the community because of your criminal conviction, and you can show that you are not a flight risk, that you'll show up for your immigration court, then you might be eligible for bond. Here in Omaha, the bond amounts for immigrants have been around $5,000 to $8,000. And it's not like criminal bond where you can pay 10% and have a bond company cover the rest. For immigration court, it's cash bond. You have to pay the whole amount.
The whole amount
all
in
at
full.
once.
Okay.
So that's one difference. Another difference is the amount of time that you have to prepare your case if you're detained versus non-detained. In the detained court, here in Omaha specifically, there's an average of about 60 days from start to finish. In the non-detained court, it's closer to 2, sometimes even 3 years.
Okay.
So that gives you more time to present your evidence, gather your evidence, find an attorney to help you.
Okay. So to clarify this moment a little bit more, when you say detain and not detain, detain is someone who is in a building, and not detain is someone that is allegedly has violated the immigration law but can stay outside and still follow the progress of the case from outside. Is that right? Do I have it correct?
That's correct. So
Okay.
immigrant detainees here in this area generally are detained in county jails who have a contract with ICE.
Okay.
But yes, they're kept in that building for some reason, usually the gravity of their criminal offense.
Okay. All right. And how about the removal proceedings? How long does it take? What is the typical time average for having a case from the court, the decision made to put that immigrant into the plane or the bus back to his own or her own country? How long does that take?
First, we would hope that the outcome is that they're not removed.
Yes, I agree.
But the timeline from beginning to a final decision varies depending on the case and what type of defense you're presenting. But generally, as I said before, in the non-detained court here, the average is about 2 years.
2 years.
So from the time you get a notice to appear to when the immigration court first orders you to present yourself before the court, that can be a matter of months. It can be weeks. For those who are found at the border when they cross, their first appearance is usually very quick.
Okay.
And they're often removed very quickly.
Okay.
For an asylum case, because there are so many issues to iron out at those master calendar hearings, those can take much longer. And then also after the master calendar, you're scheduled for usually a 3 to 4 hour, what's called individual hearing or a merits hearing. And that's where you finally present all of your evidence for your defense. You give your testimony. If you have witnesses, those people can testify on your behalf as well. And then usually a matter of a couple of months is when the immigration judge would give the decision after that individual hearing.
Okay. If the judge decides to continue with the removal order, then the decision can be appealed within 30 days to the Board of Immigration Appeals. If it is still a no, then the decision can be reviewed by the Circuit Court of Appeals, again, within 30 days of BIA decision. And lastly, to the U.S. Supreme Court, if accepted. In your opinion, what is the gravest problem that the immigration court system is facing right now?
So in my opinion, as an individual, not representing my organization, I think one of the gravest problems is the number of cases that the immigration court has pending. Some estimates put it up to close to 1 million that are either active or inactive, and that we definitely see that here in Omaha. The backlog is huge. So that prevents people from having their day in court. I think another problem is the independence of the immigration court, both managerially and with the decisions that they can make. Because it's part of the executive branch,
Okay.
And it falls under the Department of Justice, so the Attorney General of the United States oversees, has a final say on how the immigration court acts.
What your suggestion to fix the system would be then?
So, along with many other attorneys and even former immigration judges, one thing that I would suggest is an independent immigration court, separate from the executive branch, where they would have the chance to docket their own cases, decide when to hear certain cases, and then also have a little more decisional independence based on the laws as they are.
Okay. All right. Well, thank you, Jacob. I think we've, I do have one more question.
Yes.
To bring it down to Omaha level, how big is the immigration court in Omaha? How many judges do we have in Nebraska? Omaha and Nebraska.
Yeah, so currently there are 2 immigration judges, and the immigration court in Omaha covers all of Nebraska and all of Iowa. So one of the judges is hearing non-detained cases, and then the other judge is hearing detained cases.
Right.
There is one more courtroom in the Omaha Immigration Court that is empty right now because there was a judge who retired in March of this year. So we imagine that'll get filled eventually, and they are currently using it for video teleconference judges.
So potentially Nebraska and Iowa may be served by 3 judges. We'll have 3 judges.
Correct.
All right, and I needed that number to conclude our discussion.
Okay.
Thank you, Jacob.
Yes.
All right, and this was Legal USA for this month. Next time we will cover Special Immigrant Juvenile Status, or SIJ. If you have questions, please email us at legal@newamericansmedia.com by June 19th and receive your answers here on July 1st. Please follow us, watch us on KPAO TV or online at www.newamericansmedia.com. Thank you for watching. I am Enkela Bebil.